All right, peace and blessings. March the 21st, the year 2018. We're going to start with page 201 and try to get to page 250 today if we can. I always say this at the beginning of a reading. I wish you guys had a professional reader, but we don't have a professional reader. We got me. And so we're going to do the best that we can. The top of page 201 of the book Cesspool of Judicial Corruption, the David Hinkson story. He contacted Raff's two brothers in Mexico and learned that they were not hitmen but were responsible businessmen. After repeated demands that the FBI look into the matter, it took 17 months for Agent Long to contact these men and verify that Raff's allegations were false. David had, in truth, trusted Mariana. She could translate for him and didn't know of Lonnie Birmingham's close involvement with Mariana. She had been a housekeeper for David, but when they went to Pueblo, Mexico, Mariana substituted David's bank account number with her uncle's. $80,000 of David's money was thus misappropriated. After returning home, Mariana burglarized David's house in March 2003. In that burglary, she stole $6,000 cash and a credit card from David and drove to Lewiston, a town of 40,000, an hour and a half from Grangeville, and withdrew another $600 using David's credit card from an ATM machine. She had his PIN number. When David discovered her theft, he fired her and announced over the company loudspeakers what she had done. However, as mentioned earlier, David reported the theft, went to the sheriff's office, but was himself arrested instead of Mariana. They locked him up and threw away the key. Of course, the authorities never returned the money to him. We later learned that Mariana needed $6,600 for a down payment on a house she wanted. Yet the authorities did nothing to her for her crimes against David. This was the third time she went to jail over a crime spree that started in January and ended in July of 2004. As to how cold-blooded Mariana Raff is, when her former husband, Quinn Raff, now deceased, was deathly sick with a brain tumor, she said she was glad he had life insurance and hoped he would die. She stayed with Quinn until she met the 10-year-old moratorium for immigrant brides, then immediately split. She wound up jailed in Clearwater County and again in Nez Perce County for various charges: forgery, burglary of a postal facility, and a drugstore for counterfeiting money and green cards, etc. The feds dropped all charges against her while she was yet on her crime spree. Wes Hoyt called Lonnie Birmingham, another disloyal employee opportunist, and questioned him on July the 16th, 2004. Lonnie told Mr. Hoyt she, Mariana, was glad to say bad things against Hinkson, like he hired her brothers as hitmen because it kept the FBI happy, and also because she enjoys getting even with Hinkson. She feels he really screwed her. Birmingham also said that it had been a big mistake for Hinkson to get mad at Mariana, and it was a bigger mistake to fire her because she really knows how to get even with Hinkson, and she is doing so by telling lies about him to the FBI. Lonnie felt it was all Hinkson's fault and for firing her anyway. Yet Lonnie admitted that Mariana was a clever liar. Both Idaho County Detective Scott Mealer and FBI Agent Will Long wanted her cooperation, since they caught her with cocaine in her jail cell, and they had traded leniency on her criminal drug charges for her testimony against Hinkson. Mariana told Lonnie that she and Mealer are real close, and that she had traded sexual favors to him to have criminal charges dismissed. From an affidavit of Wesley Hoyt regarding telephone call with Lonnie Birmingham of July 16, 2004. We have no testimony by Mariana regarding David, although we know that AUSA Wendy Olson used a writ of habeas corpus to get her out of the Idaho County Jail on March the 4th, 2004, to testify before a grand jury in Boise regarding David. Lonnie quoted Mariana saying, "David is so stupid he trusted me. I've got enough on him and I'll bring him down." Lonnie and Mariana shacked up for several years. Lonnie left his wife and children to live with Mariana, and together they were reportedly heavy users of drugs. We believe that Lonnie may have been charged with possession of a controlled substance, and that federal officials may have had those charges dropped or exercised their influence to prevent charges from even being filed against him, as they did with Mariana, as leverage to get Lonnie also to make up false stories about David. Another employee, Debbie Morley, said Mariana is an excellent liar. Mariana claimed in her FBI 302 report on April the 1st, 2003, that when she, Lonnie, and Dave were in Mexico on a business trip looking for property for a Water Oz facility, Dave solicited her Mexican brothers to kill AUSA Nancy Cook and IRS agent Steve Hines, but that she would not give out the name of her brothers. Quinn Raff called her brothers in January 2004 and confirmed that Dave had never discussed homicide or hitmen with them when Dave was there in Mexico. Her brothers were active church members and stressed by her lying. Mariana supposedly told Dennis Albers, the former Grangeville district attorney, that Dave tried to hire her Mexican brothers to kill him. This was useful ammunition for Albers. After the Hasselone versus Hinkson case was over, Dave and Albers had a conversation. Dave said, "Albers, you're nothing but a piece of shit." Albers said to Dave, "You belong in prison." "Why? I haven't done anything wrong." "Why? I haven't done anything wrong." "You're going to jail and I'm going to put you there. How can you do that?" "We have our ways," Albers said. The conversation took place in mid-September 2000, at the time when Albers still had a 30% favorable margin in Idaho County prosecutor campaign. Dave's letter-writing campaign followed and Albers lost his election bid in November by minus 30%. The last we heard, Mariana Raff was living free in northern Idaho, again released by the feds. David's attorney, former assistant prosecuting attorney Wesley Hoyt, did something that none of David's other paid attorneys, and certainly not any in the judiciary, did, and that is to seek the full story. The government seeks money and convictions, not truth. Our adversarial system of law rewards the attorneys who can muster acquittals. So the most successful ones make the most money. Seldom do we encounter champions for justice for the sake of justice. Like an iceberg, most is unobserved and hidden beneath the surface. Wes dug, questioned, and dug relentlessly. Here is what he observed. Had the jurors known all the withheld facts, there is little doubt that they would have been convicted. They would have convicted David of anything. He was simply minding his own lawful business, but he stepped on the toes of some government agents to bring David down. Those agents conspired with paid informants to entrap him with their fabricated stories of murder for hire. Much of the case on trial in January 2005 involved the issue of freedom of speech. Questions arose about his intense statements, such as, "God should smite them," referring to government agents who abuse their authority and the law. In taking advantage of his unrestrained vocal statements, certainly government agents relentlessly sought to destroy him. David has always used the legal system as the means of addressing perceived corruption in the system. Routinely, David made sharp and cutting statements about the corruption in the U.S. government. This behavior did not win him any friends within the system. His career as a radio host involved bringing many guests to the talk show who also criticized corruption by government officials. Publicly and openly, he stated his views on issues such as the legality or illegality of the federal income tax, of unlawful Bureau of Land Management schemes to seize property from Western private property owners, and on generalized corruption in our federal, state, and local governments. David learned the art of affecting the political process with expository pamphlets, and he takes credit in part for unelecting various corrupt politicians. He became a lightning rod of controversy and used his position as a gadfly or whistleblower to challenge the government to clean up its act. By exercising his right to free speech, David certainly gave the government cause to put him out of circulation. However, since they supposedly couldn't arrest him for the exercise of free speech, the government chose to arrest him for made-up and falsified stories of murder for hire of federal officials, based purely on hearsay. To support their fabrication, the government conspirators substituted accuser Swisher for the former accuser Mariana Raff. Raff was their first choice informant, but they finally dumped her due to the many felonies she persisted in committing while they were using her. Now that we had the evidence on the government's fraud, it was time to go to the honorable courts, but we need a choice spokesman with clout. Chapter 30. Our hope to enlist a top appellate attorney. On July the 8th, 2005, Faye and I drove to San Francisco to meet with attorney Dennis Reardon. Wes Hoyt flew from Denver, Colorado to our meeting. Wes had tried to get Mr. Reardon on David's case earlier, but Reardon was involved in another time-consuming case that he had just won. So Dennis was willing to at least listen to our plea for his expertise in handling David's appeal. Emmy Award-winning journalist Charlie Rose praised Dennis Reardon as one of California's leading criminal appellate lawyers. On his website, he praises Reardon's accomplishments. He has been listed among the best lawyers in America and is a member of the California State Bar, the New York State Bar, and the Bar of the United States Supreme Court. 1st, 2nd, 5th, 9th, and 10th Circuit Court of Appeals. Reardon received the Skip Glenn Award for Outstanding Advocacy from the California Attorneys for Criminal Justice and the Merit Award from the Bar Association of San Francisco. He taught at the University of San Francisco Law School and served as a Deputy State Public Defender at the State Public Defender's Office in San Francisco. His writings appear in books and newspapers, including Criminal Defense Techniques, 1979, Jury Work, Systematic Techniques, 1983, Political and Civil Rights in the United States, 1976, to name a few. Mr. Reardon is well known in the Ninth Circuit, and he didn't just jump in to take David's case. He said he'll review the case and let us know. "What questions do you have?" he asked. "About me and the process? Why did you come to me, Roland?" I said that we've been ripped off by all of the attorneys to the tune of over $2 million at that time. Tiger, an acquaintance of his, calls you Dennis, the best. I told Reardon that I no longer believe in the system based on personal experience and of testimony from those whom I trust. We're looking at you to help David and help save the country. Talman is a criminal, I said, and should be charged. I also told him about Swisher's lying and deceit. Steve Anderson, another big high-powered attorney, joined the conference on the telephone. Reardon asked Steve if he had read the tax case, etc. He said he only read the items for the sentencing issues. Steve talked about the structuring and guidelines for upward departure. The appeal, Reardon said, may not address all the things we are concerned about. This may be a disappointment to you. Anderson mentioned that the scheduling dates are the same in both cases. We should order the 2 sets of briefs on the date of the secret hearings, and that we want the hearings transcripts, and that we're in a camera judge's chambers. Steve Anderson said there is something called a willfulness requirement. West talked to Dennis about appealable issues and reversible error, and that we may have dozens of appellate issues. West said we're looking for some novel approach. We need a hook, suppression, liability, Brady, Giglio, ineffective assistance of counsel, etc. I learned that a 2255 proceeding is equivalent to a habeas corpus. West said Roland and Fay are steeped in legal aspects of this case. He said that he is only a civil attorney. West explained the tax case and threats to Reardon. On the tax case, David was pro se. West couldn't get anyone to take the threats case because of the icky factor. He said under the old system, Davids could have appealed by saying, "Hey, you're holding me improperly." The courts now ruled that as long as there is a remedy, that's what you'll have to talk about. Congress passed a law, Title 18-2265, which says if you're going to challenge something, for example, the attorney did a bad job, that's what you talk about. Example, government misconduct. It's kind of like as a second appeal. West said that not one attorney in Idaho would take David's case. West shopped the state for a criminal attorney that could take the case but without success. It was the icky factor again. West told David's story about his arrest, the judge, Lon Horiuchi murder, and windmill recusal, the judge who postponed sentencing until they tried both cases. He said that they convicted David on 404B evidence. He went on and talked about Swisher's testimony about Lodge, Hines, and Holson, and about Sean Connolly's ineffectiveness of counsel. Sean had told West the IRS case could cause the government to collapse. Sean had recently become a judge. Without disparaging Tom Nolan as lead counsel, West explained why we hired him. Reardon knows him through a murder case that Dennis tried. Our complaint was that Nolan wouldn't learn the case. He was great at cross-examination. West did all the preparation. Nolan just wouldn't ask necessary questions or learn the background of the case. Nolan admitted he botched the cross on Swisher's testimony. Reardon even suggested that a proper tactic would be to attack him as ineffective counsel. Reardon confided, "I don't doubt David's innocence, but I've won cases where I have no opinion of guilt or innocence. I hate government abuses and I want to burn them. If the appeal were a Parcheesi game, you'd want the best Parcheesi player in the game. We're talking about going after a judge of this same court. We don't know who we'll get. It could be somebody who agrees with Talman's ideology or someone who disagrees. So it's going to be a very difficult and complex case. I have never gone to trial where one of the judges I was going against for a client sits on the appellate court." West said, "I filed a motion for a new trial in the solicitation case." He also said, "I know David was ineffectively represented in both cases. Looking back, I can see my part in the ineffective representation. It was scrambling representation, trying to do what I could. Dave might not have owed any taxes. This raises the issue of sentencing on the tax case. West said, "I'm willing to say I screwed up." Reardon said it is unlikely that we can raise any of that until the appellate proceeding is completed. If you win the appeal, you can get a new trial. The exception is by claiming insufficient evidence as your defense. West said Talman told him there are a number of appealable issues. This is the second case Talman ever tried. Waterrise has been compliant in paying all taxes for over a year now, although David has signed over a power of attorney to the IRS to take any tax they claimed. West mentioned the 7202 and 16 structuring counts. West said the IRS thinks David owes $1 million or more in taxes. He said, we're looking at a possible 2255 and retrial. Also, there is a Title VII discrimination case and minor civil issues. West told Reardon the details of the rest of David's story. He talked about Talman's denials of motions that David was outside of U.S. when all these accusations were supposed to have happened, and that Talman had admitted to error in the record. West said that there was failure by the government to prove any taxes were even owed. Nikki Farrell, IRS investigator, he said, talked to 2 or 3 people and concluded that David owed taxes on 100 or so people who she claimed worked for Waterrise. Truth is that David had no reporting requirement. There is a willfulness requirement, West said, and that David is a national treasure. The whole thing was a setup by the conspirators, including FBI agent Ted Gunderson, 404B witness, FBI agent Long, and Elvin Joe Swisher. West continued telling him about the body wire and the whole story after the arrest. He said they even accused me of conspiring with Dave to kill Judge Talman. I withdrew from David's case after the verdict. Reardon said if you do a 2255, you become a witness, not counsel. However, West can cooperate and assist in the appeal. Then we discussed money issues. He said if you raise a motion for a new trial before conviction, it will be timely. Fortunately, we did raise it. Swisher's fraud was brought out during the trial. Therefore, we can raise it on appeal. But we couldn't bring in more issues. For example, Dennis explained that we couldn't mention Swisher's rapes or other crimes. You can't use it on appeal. A 2255 statute now replaces habeas corpus, but you can't bring the 2255 unless you lose your appeal, at least in the Ninth Circuit. You may want to put it all together, but you can't, he said. Reardon won a case where the president of the Bar Association was involved in the web text scandal 1970 through 1980. We discovered that the witness was lying, he said, and information was not in the record. Mr. Reardon explained, issues of ineffectiveness of counsel are always reserved for later. I'm extremely familiar with the doctrine of ineffectiveness of counsel. I raise it continuously. Be cautious. The legal standards are much higher than that if the prosecutor made an error. You want to, if you can, show that the court wouldn't allow the attorney to put on evidence rather than that he didn't put it on. If ineffectiveness of counsel is raised, the government gets every piece of paper you have, all privileged newspaper files, etc. Reardon said he'll look at everything and then let us know if he'll take the case. Reardon said it is unlikely that we can raise any of the issues until the appeal proceeding is completed. If you win the appeal, you can get a new trial. If the trial was unfair, you win on appeal. They'll have a harder time getting a conviction, and now we're down to only 3 charges. But will Reardon take the case? We couldn't get any support in Idaho at the district court level. Now David's life and hope of justice hangs in the balance. Chapter 31. Reardon says, I'll take the case. Several days later, Reardon called West and said this case is bullshit. I'll take the case. On March 11, 2006, Reardon filed an appeal. Much of the appeal was merely a reiteration of the facts in the trial transcript. He knew he had to concentrate on the most pertinent issues, considering the time restraints, 20 minutes more or less. David's conviction rested solely on the testimony of Elvin Joe Swisher, but Swisher's corroborating accusers also need discussion. In addition to Swisher's testimony, he discussed Bates, Harding, and Bellin's testimony because even though acquitted of the charges, the judges considered the accusations and merging them carried more weight. So, he said, the summary of the evidence as to those counts can be brief. Reardon started by clarifying a few things. He argued that Harding and Bates' testimony, whatever the content may have been, did not rise to the level of criminal conduct since Hinkson was acquitted of the first 3 soliciting charges related to Harding's testimony and of the 2 counts of threatening federal officials, to which Bates testified. And the jury was unable to reach a verdict on the other Harding charges. It convicted Hinkson of the Swisher solicitation charges only. He quoted from the trial transcript questions and answers, but mostly he concentrated on Swisher's statements. He mentioned Chad Kroner, who was incarcerated in the Ada County Jail with David. Government agents AUSA Sullivan and FBI Mary Martin worked out a plea bargain with Kroner that if Kroner would testify that David had wanted to hire him for $10,000 to kill the trio, Kroner would get a reduction in his sentence and the charges against his mother for another crime dropped. The following is from Reardon's brief. Kroner received a favorable sentencing recommendation in exchange for his cooperation. According to Kroner, Hinkson told him that he had offered Swisher and Harding $10,000 to get rid of Lodge, Cook, and Hines. Shortly thereafter, Kroner met with the FBI and agreed to work as an informant on Hinkson's case. Hinkson presented several witnesses also in jail with Kroner and Hinkson who testified they never heard discussions of illegal activities and that Kroner was generally dishonest. Chad had lain on his bunk for a couple of days, hardly speaking to anyone. The defense argued it was entitled to a mistrial because Swisher had produced a falsified document to support his claims regarding his military background. Your Honor, we have a document given to us by the U.S. government which is false, and the government knows it's false. The AUSA Sullivan responded, I have no evidence or reason to believe that the document is false. The court, Talman, denied the mistrial motion, also stated that the document produced by Swisher appears to be genuine, and that it was consistent with Swisher's testimony about his combat service, and ruled that the government had no reason to believe that Swisher's document was disclosable under Brady or Giglio because it was not impeaching. The court suggested that it could not evaluate the matter unless the defense could produce a qualified person, such as a records custodian from the National Personnel Records Center, to explain the meaning of the documents. He suggested that the documents were rank hearsay and also extrinsic evidence under Rule 608B. The court suggested the credibility of Swisher's claims was still disputed and that the government would be able to submit conflicting documents and experts showing that Swisher was indeed telling the truth. The court said such an inquiry would require considerable time and that it would only serve to confuse the jury, since it would have no way to determine which documents to credit. Lacking the ability to submit any evidence contradicting Swisher's claims, the defense decided not to recall him to the stand. In his closing argument, AUSA Sullivan argued that the jury should consider Swisher an entirely credible witness because, rather than being an enemy of Hinkson's making false accusations, Swisher was a person who liked Hinkson. Mr. Swisher's testimony is powerful. He talked about how Mr. Hinkson understood that Mr. Swisher had been in the military and had killed a lot of people. He, David, was very impressed by that. The defense argued that new evidence conclusively proved that Swisher had been lying, that Swisher had committed a fraud on the court by producing the bogus document on the stand, and that the government had committed misconduct by failing to disclose material that would have undermined Swisher's credibility. First and mid-trial, and the lower court deprived Hinkson of a fair trial, and it ruled inadmissible documentary evidence which would conclusively have demonstrated that, contrary to assertions in the government's opening statement, Swisher had never served in Korea and had lied to Hinkson, law enforcement officials, and jury where he claimed to have killed many times in combat. Second, the government deprived Hinkson of due process when it sought his conviction on the basis of Swisher's testimony, while deliberately failing to correct the false impression created by that testimony, that Swisher was a battle-hardened killer. Finally, the court plainly erred in denying Hinkson's new trial motion, which rested on additional and uncontrovertible evidence that the defendant's convictions had been obtained through the knowing use of perjured testimony. Reasonable jurors would not likely have taken seriously these purported conversations if they had learned that Swisher's tales of killing on the battlefield were wannabe fantasies, that in fact he never had come anywhere near combat. Hinkson's documentary proof would have been devastating to Swisher's credibility, marking him a pathological liar. Swisher sued Don Harkins of the Idaho Observer for $5 million, and me, Wes, and Greg for calling him a pathological liar. The court, the Ninth Circuit, has repeatedly held that evidence that a government witness told lies during the investigation of the case on trial is relevant and admissible. He, Swisher, thus had a huge personal and financial incentive to testify in accordance with the supposed facts contained in that document, an earlier grand jury hearing. If he admitted his lack of combat experience, he would not only stand to lose his disability payments, but would expose himself to prosecution for defrauding the government. Proof that the replacement DD-214 was a forgery could have led the jury to reasonably conclude that the informant had a motive other than altruism for testifying on behalf of the government. Such a finding could have substantially impeached the informant's credibility as a witness. Hinkson's right to introduce the evidence of Swisher's perjury was of constitutional dimension. Defense attorney Reardon then went on to detail how Rule 608B and Rule 403 on evidence had been misapplied by Talman. A lie is a lie, no matter what its subject, and if it is in any way relevant to the case, the district prosecuting attorney has the responsibility and duty to correct what he knows to be false and elicit the truth. Dennis cited a couple of current holdings. If the government was to pursue a conviction in this case after learning of Swisher's perjury and proffering of forged documents, it had to inform the jury of the truth. The government of a strong and free nation does not need convictions based on false testimony. While David continued to mark time for over 2 years in his solitary dungeon at ADX Federal Penitentiary, the Ninth Circuit finally rendered their decision. But for David, the wait was painful. However, he used his time to the best advantage. He asked for Spanish and Russian primers, dictionaries, and books to read. Although he never heard the pronunciations, he learned over 5,000 words in both languages. He struggled with his personal regimen to exercise in his tiny cell trying to stay fit. Occasionally, guards would raid his cell and remove any of his personal possessions. When he boiled over with delusionments and anger, he would call us using one of his 15-minute phone calls that they allowed 4 times per month and vent. Is there something wrong with the methods of the government today? Former Assistant Prosecutor Wesley Hoyt unequivocally accuses the federal government of prosecutorial misconduct, outrageous governmental conduct, and vindictive prosecution. He asked for dismissal of the phony charges against him in a motion for new trial, to which the Ninth Circuit Court of Appeals agreed, but then in a later decision took back the first opinion of reversal and reaffirmed the trial court's decision of conviction. Hoyt asserts that David was falsely accused by multiple government informants, and there is ample evidence of corruption to prove it. Chapter 32. Government's Crimes and Recommended Punishment. David's attorney, Wesley Hoyt, in his early career had served in Idaho County for 4 years as an assistant prosecuting attorney about the time Richard Talman was a law student. In his exhibit to the court, he presented to Judge Talman, who should have learned the basics of law, a statement of fact to dismiss the entire case based on prosecutorial misconduct, outrageous governmental conduct, and vindictive prosecution. He wrote, "A prosecutor's job is first to see that justice is done. The prosecutors in this case have been focused solely on obtaining convictions at any cost, even at the expense of compromising their own integrity and participating in violation of the very laws they are sworn to enforce." Swisher, a government informant who declared he was just repeating what Mr. Hinkson had said to him out of court, i.e. hearsay, was allowed to recite the details of a request for a torture murder that he claimed was Mr. Hinkson's plan for the death of 3 federal officials. These were hearsay statements that were supposedly made by Mr. Hinkson and were admissible because of a technicality in the rules of evidence. Generally, a person is not allowed to repeat what another person said out of court or hearsay, which is excluded from the evidence at trial. However, because of an accepted deviation from the general rule, known as the admission by party opponent rule, Federal Rules of Evidence, Rule 801D2, Swisher was allowed to spew forth a litany of false and fraudulent statements about Mr. Hinkson. They were unchecked, made up by him concerning the supposed solicitations for murder of these federal officials, purportedly requested by Mr. Hinkson. There are no rules of evidence that prevent a liar from making such wild claims, especially a liar who has the skill and finesse of Swisher. Ironically, Swisher was able to present these lies to the jury with impunity. Only a proper investigation by prosecutors motivated to do justice could possibly have prevent this kind of travesty. Here, in spite of a strong indications that Swisher was lying, rather than looking into the military record of Swisher to be certain that it was correct and not a forgery, the prosecutors, whose only motivation was obtaining a conviction, ignored their duty to investigate. Yet a prosecutor has a special duty to prevent and disclose frauds upon the court and to guard against due process violations caused by false testimony. Former Congressman Robert E. Bauman, J.D., from Maryland, explained in a publication that there is a rule, Rule 4, known by insiders. It is almost all police lie about whether they violated the Constitution in order to convict guilty defendants. Perjury is the most widespread form of police wrongdoing. He noted that it even has a well-known nickname among the courthouse, cognoscenti testaline. Recognition of the widespread corruption prompted a bill, H.R. 4276, August 31st, 1998, to be considered in the 105th Congress 2D session. Part of it was to establish ethical standards for federal prosecutors. This bill never made it into law, unless I have just failed to discover it. However, it would have corrected serious abuses by law enforcement officials. It provided under Section 821A violations, the Attorney General shall establish by plain rule that it shall be punishable conduct for any Department of Justice employee to violate any of these provisions. 1. In the absence of probable cause to seek the indictment of any person. 2. Fail promptly to release information that will exonerate a person under indictment. 3. Intentionally mislead a court as to the guilt of any person. 4. Intentionally or knowingly misstate evidence. 5. Intentionally or knowingly alter evidence. 6. Attempt to influence or color a witness testimony. 7. Act to frustrate or impede a defendant's right to discovery. 8. Offer or provide sexual activities to any government witness or potential witness. 9. Leak or otherwise improperly disseminate information to any person during an investigation. Or 10. Engage in conduct that discredits the department. The Attorney General shall establish penalties for engaging in conduct described in subsection A that shall include probation, demotion, dismissal, referral of ethical charges to the bar, loss of pension or other retirement benefits, suspension from employment, and referral of the allegations, if appropriate, to a grand jury for possible criminal prosecution. The problem is that the good old boy syndrome is at work here. No one who attacks the system will prevail. The corruption within the out-of-control government is well entrenched. It is no longer a question of whether you live an honorable life, rather it's a question of how well you are connected. Whether all of the federal participants in this case believe that they were doing right does not mitigate ultimate damage to my son, David Hinkson. Regardless, at the hands of the United States Deputy Marshal David Meyer, he cast our son back into his dungeon-like cell at Ada County Jail, awaiting transport to the ultimate dungeon, Supermax ADX in Florence, Colorado. We got to talk to David on June the 7th, 2005, but the next day he boarded a prisoner plane bound for Oklahoma. As far as we knew, he was off the planet. Until we got a call from him on June the 23rd, he was allowed one 15-minute phone call. In spite of all the depressing events, I wrote to David letting him know that I'm proud of him for his strength and honor and that he is truly a man of conviction and stature. I wrote to him while he was in solitary confinement. As you know, David, there's no doubt in our minds that you are a victim of a ruthless, uncaring bunch of criminals. These criminals come in many forms, sometimes as FBI agents, sometimes as IRS agents, and sometimes as judges. Swisher is an incorrigible rogue. His crimes include forgery, fraud, theft, and blackmail. Hopefully we can bring the conspirators before the bar of justice for the prosecution. But since some of the culprits are in government, we may get only justice in the court of public opinion. Humiliation and dishonor may be their only punishment, time will tell. Attorney Wes Hoyt sums up the case in his own words and tell why each of us must now watch our backs, not as much from ordinary crooks, but from government. Chapter 33. Wes Hoyt views the panorama. Wesley Hoyt continues his chronicle. Swisher appeared to have credibility, and he attributed radical statements to Mr. Hinkson. The government agents brought in others on the same bandwagon who made exaggerated statements as well. All of the participants had a financial or revengeful interest in the outcome of the case. Swisher, in participation with Richard Bellin and others, attempted to take over Wateraw's business and properties. Bellin, Swisher, and others obtained a temporary restraining order, TRO, under false pretenses from the Idaho County Court. Although vacated, the TRO permitted Swisher, Bellin, and others to take control of the business for 8 days. During takeover, much damage was done to the business. Even customer files were removed and not returned. However, Swisher and his cohorts were ousted by court decree, and Mr. Hinkson's management team was restored to the Wateraw's business. Swisher attempted on several occasions to obtain a foothold in Mr. Hinkson's lucrative Wateraw's business. He erroneously reported his analytical readings as if they were consistent with the label, when in fact the product's parts per million mineral content actually fell short. Those readings created FDA product labeling violations for Mr. Hinkson. He was not aware of the deficiency. Hinkson had relied upon Swisher as an expert in analytical testing field to provide true and accurate information. The product labeling violations were then used as a pretext by the government under a claim for immediate protection of the public health to obtain the July 2002 indictment. Hinkson is a pioneer in the field of dietary mineral supplements, whose North Central Idaho home and water bottling facility, Wateroz, was raided by a combined 50-man federal SWAT team in November of 2002. At that time, Mr. Hinkson expressed concern that 25 masked machine gun-toting government agents dragged him out of his bed at 5 a.m. just to enforce alleged FDA labeling and IRS tax filing laws. Hinkson was immediately released on his own recognizance. Charges range from failure to file income tax forms, produce labeling errors, and bank reporting violations. Subsequently, in May of 2004, he was convicted not for tax evasion, as incorrectly reported, but for failing to file income and employment tax returns. Absurdly, he was convicted as well for withdrawing on 2 occasions within 24 hours his weekly cash payroll, nothing illegal. In April 2004, just prior to trial in the tax case, Hinkson pleaded guilty to 2 vicarious offenses. As the party responsible for a business, the FDA charges were misdemeanors and involve highly technical labeling violations for dietary supplements. Once the government handed down their indictment July 17, 2002, they held it for 4 months without doing anything. They claimed it was to provide for the immediate protection of the public health. Instead, during the 4 months, the government positioned itself for a preemptive strike against Hinkson's home and factory. The strike was orchestrated by the very same government agents who had maligned Mr. Hinkson for years, whom he had sued for $50 million because of the alleged governmental misconduct. These same agents were suddenly, by the issuance of the FDA search warrants to protect the public health, empowered to attack Mr. Hinkson with impunity, applying the level of force they deemed appropriate. In his testimony before a federal grand jury in April 2002, Swisher presented a glowing report of Wateroz and its owner, David Hinkson. At that time, he was being paid by Wateroz for product analysis, and his erroneous reports had not been discovered. Nor was Mr. Swisher forthcoming with his allegations. For a year, he remained silent, itself a crime, misprision of a felony, while he planned his takeover of the Wateroz business. Contrary to Swisher's claim that he was a decorated war hero, the public records confirmed that he was a liar and a forger. In addition, Swisher's claim of being an injured war veteran enabled him to fraudulently obtain medical benefits from the Veterans Administration to which he was not entitled. Hinkson asserts that Swisher made up the claim of solicitation of murder to put him in jail so that Swisher could grab Hinkson's property, which he coveted. Mr. Hinkson was not permitted to present the evidence of Swisher's fraud, so that the jury was in essence hoodwinked into believing that Mr. Swisher's testimony was credible. Hinkson was initially imprisoned April 4, 2003, and has been held ever since on preposterous stories that made absolutely no sense except to the government fiction writers who concoct their fables to justify the arrest of an innocent man. In an effort to bolster an otherwise preposterous fabrication, it became necessary for the government, after the initial arrest, to find other implausible witnesses, such as Mr. Swisher. In addition, Hinkson was arrested for allegedly violating conditions of his pretrial release. Purportedly, he solicited the murder of 3 federal officials while on bond. The charge of solicitation for the murder of 3 federal officials is commonly used in Idaho by the federal government against innocent people. By accusing people of solicitation for murder, the government is required to use 1 or more of its 15,000 plus payday informants. These informants are trained to lie under oath with court-authorized use of stealth and deception. The informants will lie against any person who has been designated as the target of a government investigation because it's their job. The FBI in Idaho has become emboldened by the fact that the courts will not regulate the use of stealth and deception. They have now accused Mr. Hinkson's legal team of being co-conspirators in a plot to murder federal officials. The implausibility of this new murder-for-hire plot has become the government's latest and greatest fiction in the saga of David Rowland Hinkson, and surpasses all comprehension. However, this latest incident of accusing Mr. Hinkson's attorneys points to the real source of the problem. Let's be clear, the government is becoming desperate. It attempts to implicate innocent people for crimes that did not occur simply to justify the forfeiture of property to pay for more informants. The government, having been empowered by the courts to engage in a broad range of techniques and methods to disclose criminal activity through stealth and deception, have now stooped to an all-time low. They now accuse any innocent person who dares to oppose them of murder for hire of federal officials, and we are learning that mostly the money figure is $10,000. In this case, all informants for government were either disgruntled former employees of Waterhouse with a grudge against David Hinkson, or they were persons with an economic interest in seeing Mr. Hinkson jailed. Unfortunately, our court system does not require second accuser to corroborate the statements of a person such as Elvin Joe Swisher. After the verdict in the tax case in late June 2004, and after Mr. Hinkson had been held in jail for 1 year and 3 months, an indictment was finally issued against him. The indictment issued for 11 counts relating to alleged statements of threatening harm to the federal officials. It is upon this indictment that the jury returned its mixed verdict on January 27, 2005. The root of the problem is that in its last revision of the money laundering law in 1996, Congress failed to tie the use of the money obtained in a structured transaction to criminal conduct. By removing criminality as an element of any offense, Congress has opened a Pandora's box. By allowing the government prosecutors to prey upon American people for innocent conduct where no criminal intent exists, it is turning ordinary banking transactions into criminal law violations. Hinkson says, if they can do it to me, they can do it to anyone. Mr. Hinkson, as a former national talk radio host, says that no American is safe from indictment under the new structuring law. You may not intend to do so, but if you bought a used car with $9,000 cash down, that was drawn out of your bank account on day one, and day two you paid off the balance with $5,000, also cash from your bank account. Congratulations. You've just structured a currency transaction. You've now committed a federal felony, and you are now the subject of government prosecution with asset forfeiture and 5 years in prison. Beware, those of you who simply withdraw cash, cashier's checks, travel checks, or money orders in an amount of greater than $10,000, which is split over more than 1 day, you are in violation of this structuring law. David Hinkson then became a political prisoner of the United States. That means he was in jail for 1 year. Before he went to trial on the counts of failure to file income tax, it was Mr. Hinkson's analysis of the federal tax code that led him to the determination that he was not a person required to file tax forms during 1994. In 2000, when the tax investigation began against him, Hinkson endeavored to engage the IRS in a civil law. He sought to have a jury resolve the question whether he was a person required to file tax returns. When in March 2000 he demanded trial by civil jury, the IRS, who had previously advised him in writing that the investigation was civil, immediately turned the case into a criminal prosecution. This precluded Mr. Hinkson from litigating the applicability of the tax law as it applied to him. Is David's case one that's just slipped through the cracks of the Justice Department? Maybe some people are seeing a glimmer of foul play. Chapter 34, are the cowards the ones quick to judge? I received a letter in June of 2007 from another federal inmate and then sent him the following letter. Daily, we learn about how so many more Americans are losing their freedoms. Over 7 million Americans are either in prisons, jails, or they are on parole or under the control of the system, and over 2 million behind bars. Each year, 10 million people are arrested. I suspect that 40% or more are either innocent or overpunished for violations of the 60 million laws of this nation. As you may know, it cost David and us over $3 million, now over $4 million, to fight the criminal conspiracy perpetrated by the IRS, FDA, Justice Department, with the help of a black-robed prosecutor, Ninth Circuit Court Judge Richard C. Talman. They pulled every string to achieve their goal, not to get the truth, but to convict David at any cost. Fortunately, Dave was acquitted of, or the charges dropped of all but the testimony of one forger, perjurer, and despicable liar, Elvin Joe Swisher. Now he has been exposed, but the government is hesitant or may never willingly prosecute him. However, after we involved the right powers, they finally acted. Your story smacks of the same sick disregard for law and order by the untouchable villains within government. Amoral judges and politicians without backbone or integrity protect rogue government agents and their informers. However, I admonish you, as I did my son David, to treat the guards with respect. They, in fact, are not responsible. They merely carry out the dictates of their superiors, who mostly recruit from the ex-military who just want to earn a living. My job is to expose those who don't treat you with respect and dignity. About 4 months before they arrested David, one reader of the Lewiston Tribune in the opinion letters on December the 11th, 2002, wrote about David saying, "Here is another thought on the David Hinkson issue. Along with these alleged charges, he is quite a person. I would like to see Adam Wilson do an article on the other side of the guy. There is so much that he should be said. Also, I think it would be interesting. Our company contracted some work for him and found him to be honest in his dealings. That alone says a lot. During the course of our work, we had a very enlightening experience of seeing his Waterous plant, also his equipment shop and building on US Highway 95. It is most amazing. As a major employer in the area, he could eventually rival the Grangeville Hospital or Forest Service in contributing to our economy and well-being. I would rather hope all works out for the man and his employees, and we need him. J. Carroll Atkinson, Grangeville, Idaho. The Lewiston Tribune published this only because of its policy to publish letters to the editor, which they sometimes refuse. However, government abuse applies not only to ordinary citizens, but also to any in government who blow the whistle on in-house corruption. Consider the case of congressmen who dare to speak out. Chapter 35, Idaho Congressman George Hinkson chained and thrown into prison. What has happened during the intervening years with our system of justice? We watch with dismay the transformation of our system of justice. All the truthful lawyers with whom I've conferred admit to me that our legal system is broken. Our rights as Americans are disappearing while we sleep. The Idaho Observer published a story of crime, abuse, and tyranny by the federal government. It is the story of former Congressman George V. Hinkson. I had the good fortune to visit Mr. Hinkson after his ordeal, but the story was almost unbelievable. While I was visiting with David near Grangeville, Idaho, one of David's female employees told me that she had been Congressman Hinson's secretary. The story she and others told sounded too implausible. There must be a mistake of sorts. Something was missing in the story, I thought. I looked up the name George Hinkson on the internet and found 4 listings by that name. David walked into the room where I was searching on his computer, so I told him my plot. How can I reach Mr. Hinkson? I needed to talk directly to the congressman in order to satisfy my demand for authentication of reliability. David knew him, put me in contact with a friend of his, Bill Call of Pocatello, Idaho. Bill contacted Congressman Hinkson, arranged a breakfast meeting, and we met and talked. I came directly to the point, asking Hinkson for verification of what I had heard. He clarified some misconceptions that shocked me and Faye with the intimate reality of what he endured. Even President Reagan and Attorney General Ed Meese were not able to help George. This was the turning point in my comprehension of justice in America. Don Harkins, now deceased, publisher of the Idaho Observer, and Edward Snook, the Oregon Observer, covered the story as follows. After 4 years of imprisonment, after 10 years of persecution, after being ruined professionally and financially, and after being permanently damaged physically, in December 1995, the Ninth Circuit Court of Appeals vacated Hinkson's sentence for bank fraud because the U.S. Supreme Court had ruled May 15, 1995, that Hinkson's previous conviction as a member of Congress had been overturned. They had handed him a prison term which describes the most inhumane, degrading, and painful of punishment. That is normally reserved for the most violent and uncontrollable of prisoners. The prisoner is shackled at the feet, handcuffed at the wrist, reinforced with box-like structure, which stiffens the chains and locks the wrist at a 90-degree angle. The handcuffs are connected to a waist chain that is connected to another chain, which connects the shackles. Once this shackling is complete, a prisoner can barely move. The tightened manacles pinch the nerves and restrict the flow of blood, causing severe pain and swelling. Leg swelling with blood are particularly damaging to the feet, as toenails under pressure from blood blisters press up against the shoes for prolonged periods of time and soon become infected and deformed, causing such excruciating pain that they require surgery or the pulling of the nails out by the roots. Diesel therapy gets its name not from the cruel and unusual bondage, but it gets its name by being forced into a bus and on a plane after plane, shackled as described, and being shuttled from one prison to another for weeks on end, 20 hours per day in chains, for no other reason than to cause pain and suffering and give the prisoner a massage. A message. Give the prisoner a message. Welcome to diesel therapy in the world of 7-term Congressman George Hinkson. He was found guilty in the courtroom of the infamous federal Judge Edward Lodge on bogus charges of bank fraud, which were manipulated into an issue by the Idaho Department of Finance, which illegally used the same agents previously employed by the IRS in their failed attempt to get Hinkson. After Ed Snook, the Oregon Observer, and I met with Hinkson, and he told me in the 6-hour meeting that what had happened to him, I was more shaken than I ever have been in my life. What could an esteemed member of the U.S. Congress have done to deserve such treatment? A series of events were triggered to allow crimes to be manufactured, which led to the imprisonment and torture of Congressman George Hinkson. Idaho District Federal Judge Edward Lodge, who has been used by bankers and government officials for a decade to legalize their unethical and criminal activities, was given the job of putting Hinkson away and seeing to it that he learned a lesson. Judge Lodge saw to it that Hinkson received diesel therapy, coming and going to prison from judge's court at great cost to the government, even though Hinkson should have been allowed to make such trips at his own expense. On the way from his hometown in Pocatello to federal prison in Petersburg, Virginia, Hinkson was bussed and flown, nearly immovably shackled at taxpayer expense, to jails all over the country. Not Hinkson's lawyer, his wife, nor his allies in Congress were able to locate him. Hinkson had simply disappeared for a month into the custody of the Federal Marshal Service. Hinkson's wife didn't know whether he was dead or alive, and even when the Supreme Court overturned Hinkson's original case and the appeals court vacated his current sentence, Hinkson still got the Judge Lodge treatment of another dose of diesel therapy from Virginia back to Idaho. What had Hinkson, who was a model prisoner, done to deserve the most brutal, torturous, and barbaric type of treatment this country's penal system is capable of inflicting on a prisoner? Retired Congressman Tom Kindness, Republican, Ohio, stated, "I believe that George's recent trial and conviction on charges of bank fraud was the direct result of a campaign by various members of the bureaucracy to stop the CAP. CAP, the Congressional Accountability Project, was being launched by Hinkson and a group of investors interested in good government. CAP was going to utilize nationwide television and a national 900 number to make congresspersons instantaneously accountable to the American people for their votes and the House and Senate floors. This was a project which would, in my opinion, have had major impact on the votes of congressmen, since it would have made them instantaneously responsible to the people by making their votes known immediately after being cast," commented journalist John Voss. Hinkson and his associates were on the verge of making CAP fully operational and accessible to the American public when the government, through the Idaho Department of Finance, with the illegal help of former IRS agents, a revengeful-minded Justice Department, and the corrupt Judge Lodge, manufactured bank fraud charges against him. Judge Lodge's provably compromised court ultimately found Hinkson guilty and prescribed diesel therapy to teach him a lesson. Why did the Honorable Judge Lodge treat Hinkson like public enemy number one? George Hinkson was the only member of the Congress able to pull the strings necessary to visit the hostages in Iran in 1979 and expose the big bank scam behind the crisis. George Hinkson was the author of the book To Harass Our People, an indictment of the IRS where he demanded its dismantling. George Hinkson was the congressman who was so outraged by what he discovered about the IRS while researching his book that he wrote and helped to pass the Taxpayers' Bill of Rights. George Hinkson was the first man to propose the flat tax as a damage control alternative to protect the people from IRS abuses. George Hinkson was the man who took on OSHA, WPPSS, and the INS, and George Hinkson was the man who fearlessly and repeatedly made public his findings when investigations turned up government corruption and citizen abuse. The system decided it had to teach Congressman Hinkson a lesson, because had he been allowed to continue serving on Capitol Hill, he would soon likely be the chairman of the powerful House Banking Committee. So why did Judge Lodge, whose personal reasons for needing to keep the well-documented criminal nature of the banking industry below public scrutiny, with the help of the Idaho Department of Finance, trump up a bank fraud and conviction? They did it by denying the admission of exonerating evidence in court in order to throw Hinkson in prison and make sure that he was punished severely with diesel therapy. Was it because Congressman Hinkson was getting close to the truth and accumulating the political power it would take to finally and totally expose the banking industry and government for its criminal abuses of the American people? Judge Lodge's Court of Kangaroos, CAP, was apparently the final straw, and the abusive criminal government had to shut Hinkson down. On the eve of CAP becoming fully operational, powerful special interest and political enemies derailed the project and forced a domino effect of financial repercussions upon Hinkson and his associates. The government then took the situation it had created and indicted, prosecuted, and convicted Hinkson of bank fraud. Though the treachery of Judge Lodge and government disdain, the patriotic financial sacrifices made by Hinkson supporters for good government did not prevent Hinkson from publicly pledging that these law-breaking government bullies could ever seal his lips, nor stop him from somehow paying back the people he owed and thereby keep his word. Every attorney who has read the court transcripts is concerned and confounded as to how George could have been convicted on bank fraud charges when the supervising bank officers were not only acutely aware of his financial operation and transactions, but were actively assisting him in his efforts for over 10 years. George defrauded no one, and we can prove it, stated Congressman Kindness. Hinkson was not really imprisoned and tortured by our government. Hinkson was not really imprisoned and tortured by our government for bank fraud, although that was the government's excuse to lock him up and shut him down. Hinkson was actually a political prisoner who was guilty of attempting to provide the American people with the ammunition of knowledge so they could successfully fight back against the senseless encroachment of government oppression, which more and more is ruining the lives of all of us. While in Iran, Hinkson saw firsthand what happened to political prisoners who were beaten mercilessly, who had finger and toenails ripped out by the roots, and who had been shackled until they were permanently disabled physically. Hinkson has also experienced firsthand the same inhumane torture, and it happened to him in the most civilized nation on earth, the only difference being that Hinkson was denied treatment and painkillers and had to rip his own deformed and infected toenails out. With renewed vigor, Hinkson is back and is calling on concerned Americans, including members of Congress and other elected officials, to join him in the fight to restore accountability and decency to our stricken nation. Has our government repented and stopped such tactics? Let's look at what has happened in the intervening years. Chapter 36. Trafficant survives the judicial cesspool. You may recall that the name of former Congressman James Trafficant, how the FBI hounded, prosecuted, and then tossed him into prison. Yet he vowed never to let the corruptors rest. They convicted James Trafficant in 2002 on trumped-up corruption charges about the time government agents went after David and sentenced him to prison, ultimately serving 7 long years for crimes he did not commit. James A. Jim Trafficant Jr. was born in Youngstown, Ohio on May the 8th, 1941. He received BS and MS degrees from the University of Pittsburgh. He also received an MS from Youngstown State University in 1976. From 1981 through 85, he served as a sheriff of Mahoning County. Prior to his election to the U.S. Congress in 1984, he was re-elected by overwhelming margins every year up until 2002, when following his conviction on trumped-up corruption charges, the House of Representatives expelled him. He was set up by the FBI and the Justice Department, according to Merrill Freeman, a freelance writer-investigator. It was a totally fraudulent case against Trafficant, based upon coerced and perjured testimony, fabricated evidence, and a wide variety of other non-evidence used to convict Trafficant with the collaboration of a federal judge, Leslie Wells. Ironically, Wells should have never heard the Trafficant case. Her husband was a partner in law firm that represented the interest of one of the key figures in the case against Trafficant. The FBI and the Justice Department had between 60 and 90 lawyers and agents or more working to get Trafficant. What these Justice Department lawyers and FBI agents were doing during the 4-year period that led up to Trafficant's trial in the spring of 2002 was scouring all over Trafficant's district, trying to find anything they could to put Trafficant in jail. What they did was find people in the district whom they believed were guilty of other crimes, tax evasion, corruption charges, whatever. Then the FBI and the Justice Department would take those people in and say, "We've got you. What can you tell us about Jim Trafficant? Did you ever give him a bribe? Did he ever ask you for a bribe? Did he ever do you a favor in return for a campaign contribution?" So there was this gigantic taxpayer-financed army of FBI agents and justice lawyers trying to find out everything they could about Trafficant. Youngstown had a reputation for being a center of organized crime. Trafficant himself alleged on the floor of Congress and in interviews that a faction of organized crime actually controlled the local office of the FBI as well as judges, local and federal, in the region. Thus it was, considering all of this effort by the federal law enforcement apparatus, that they would inevitably be able to find somebody somewhere who would be willing to make an allegation about Trafficant in return for getting off the hook, in return for getting a reduced sentence or some other form of favorable treatment. They did this in order to escape punishment for their own crimes that had absolutely nothing to do with their association with Trafficant. Someone accused of income tax evasion, for instance, might plead guilty to a crime in return for probation rather than jail term for having said that they had offered a bribe to Trafficant and that he had accepted it. During this time, the media in Cleveland and in Trafficant's hometown played up the idea that Trafficant was corrupt, working in concert with the mafia, constantly reiterating that Trafficant was under investigation. As a result of the media onslaught, everybody in the region knew about the investigation. Businessmen Businessmen, political figures, mobsters, everybody was looking over their shoulders and saying, I wonder if the FBI is going to come after me. And that is exactly what did happen. The FBI was approaching many, many people, and what did happen, as could be expected, is that many people concocted lies, often under FBI and Justice Department tutelage, implicating Traficant. And this is what subsequently emerged during Traficant's own investigation of the intrigues of the FBI and the Justice Department. When his case finally came to trial and the judge, Leslie Wells, frequently frustrated Traficant's efforts to bring this into the court before the hearing of the jury, in some instances the judge actually barred defense witnesses that Traficant hoped to call. In other cases, the judge limited Traficant's questioning of witnesses called by the federal prosecutors in order to prevent all of the exculpatory facts from being brought to the jury. Does any of this sound familiar? In short, people were being told, if you don't testify against Traficant, you'll be prosecuted for fake crimes and sent to jail. In some cases, these people were under the gun, simply made up things to satisfy the federal authorities. In other instances, there were those who had innocent dealings with Traficant that the Justice Department and the FBI twisted as to make those dealings appear to be criminal in nature. The old saying, of course, is that a prosecutor can get a grand jury to indict a ham sandwich, but there is no defense mechanism in a grand jury proceeding. A grand jury is conducted entirely by the prosecutors who bring forth evidence against a targeted individual who does not have the right to a defense. An individual who has been targeted can be called in and questioned by the prosecutors, but his attorney cannot come in and present a defensive cross-examination. So, after several years of work and thousands of man-hours spent, not to mention millions of dollars, the Justice Department cobbled together a multi-count indictment of Traficant. There were headlines all over the country. Controversial congressman indicted, racketeering, bribery, corruption, income tax evasion. It sounded very sensational, and most people's reaction was, oh, here's another crooked congressman. The people have the technique that... Oh, my. Hold on just one second. Hey, sweetie, I'm reading a book. Are you okay?
Post office?
Yeah, go to the post office. Do you have a key?
Yep.
Okay. All right, sorry. No. The phone just keeps ringing, doesn't it? The people have the technique down pat. At the time they were vilifying David, others were getting the same treatment in various places. I think an investigation into the Department of Justice would confirm the same pattern. Merrill continues. Even people who like Traficant started to think, he is a good guy who did a lot of good things, but he must be guilty of something. Where there's smoke, there must be fire, and that's precisely what the Justice Department and the FBI and their allies in the mass media, not to mention the Israeli lobby, wanted people to think. However, for those who actually read the federal indictment and who were familiar with the standard political corruption cases, any honest observer could only conclude that many of the charges were trumped up, if only in the sense that the charges were penny ante in nature, hardly the major crimes that the Justice Department and the media were attempting to portray. Yet even some Traficant supporters in reviewing the indictment believed, without having heard Traficant's defense, as of that point that perhaps there may have been elements in the indictment that could result in a conviction. But that was before Traficant began responding publicly to the specific charges and outlining his defense. Now that former Congressman Traficant is out of prison, he is pursuing the same recourse, exposed to criminals in government. He is fearless. The cowards that hide under rocks and steal the rights and freedoms of our citizens may yet pay a price. A recent article written by Jim Traficant gives even more insight into how far these cowards are willing to go as they try to scratch their way up the ladder of corruption to power. He declares, recent national stories have highlighted U.S. attorneys and their abuse of power. The criticism is beginning to grow from all areas of America. The Department of Justice has countered that they've only had 201 identified cases of prosecutorial misconduct in the last 10 years. These bureaucrats in Washington, D.C. maintain that an average of 20 per year is an insignificant number when you consider the number of cases they handle. The DOJ claims to have prosecuted over 60,000 cases per year, arguing that in most cases attorneys' error is most likely the culprit, not misconduct. Here are two cases to digest. Decide for yourself. The first is that of John Dimman Junk, the retired auto worker from Cleveland, Ohio, who the DOJ charged with mass murder, claiming he operated the gas chambers at the Treblinka concentration camp in Poland during World War II. DOJ prosecutors claimed that D-Man Juk was, in fact, the infamous Ivan the Terrible. Dim Jan Juk's citizenship was stripped away. He was then extradited to Israel to stand trial for his crimes. The family came to me for help. reluctantly, knowing that I was not a DOJ favorite. They had been to every congressional office and every senator's office. Nobody would talk to them. The son, John Dim Jan Juk Jr., and son-in-law, Ed Schnick, claimed to have favorable evidence that supported John Sr.'s innocence. So I investigated. An area newspaper wrote, "Traficant supports Nazi mass murderer." Other politicians at all levels said I was crazy. Dim Jan Juk was tried, convicted, and sentenced to death. But my investigation proved that Dim Jan Juk was innocent. To boot, I even proved the true identity of Ivan the Terrible, a man named Ivan Marchenko. So his first name was Ivan. Go figure. The DOJ denied my evidence. The Sixth Circuit Court refused my evidence. The evidence was delivered to the Israeli Supreme Court. After reviewing the evidence, the Israeli Supreme Court phoned me at my hotel in Jerusalem and said, "Dim Jan Juk will be delivered to you tomorrow night. Take him home." All my evidence came from the DOJ. They knew he wasn't Ivan, but they would have let him be executed. When we landed in America, the Sixth Circuit of Cincinnati, Ohio, issued a statement. A tragic but honest mistake was made by the government. Tragic, yes. Honest, no. Office of Special Investigations prosecutors should have been prosecuted for their serious crimes: subornation of perjury, obstruction of justice, violation of Dim Jan Juk's civil rights, conspiracy and complicity in attempted murder. But Dim Jan Juk was just a Ukrainian guy from Cleveland. Well, when you violate the rights of one American, you've endangered the rights of us all. The second case I know in and out because it was mine. The DOJ spent more than $15 million and assigned 250 agents to investigate me over 6 years. And our country was attacked and more than 3,500 people were killed on September the 11th, 2001 during that time. At trial, the DOJ admitted that they had no physical evidence. They even testified that they didn't have a tape recording of my voice because they didn't tape it. If you believe that, you're either naive or uneducated. Former Secret Service agent Mike Robertson said the government made tapes. They probably had boxes of tapes. They said they had no tapes because they had no evidence of crimes by Traficant, and Traficant could have used their own tapes to prove his innocence. Traficant was railroaded. 7 witnesses said they bribed me. 2 men, Richard Dettori and Namdi Okalo, stated the government pressured them to lie. 4 other witnesses testified that government witnesses confided in them that they lied to avoid prison. The judge made those 4 witnesses testify in open court subject to perjury charges, but excused the jury and never let it hear their evidence. No one was charged with perjury. They could snatch me tomorrow and send me back to prison for saying this, but the judge and the government knowingly broke the law to convict me. One last thing. The former clerk to Chief Judge Lambro's attorney, Percy Squires, testified that Judge Cafaro lied. The judge made his testimony look controversial. Now that Americans are recognizing the crimes committed by government attorneys, the DOJ is harping, "Do I hear violins? Get back at me." When a person knows what may be in store for him or her by telling the truth, it becomes a hard choice. Too few people have the courage to stand up to be counted. It might be like giving birth or having gallstones. How can you truly commiserate unless you have been there? Let's peek inside the dungeon. Chapter 37, Dungeons in America. Let's review the findings from a book entitled Criminal Injustice, edited by Elihu Rosenblatt, 1996, and excerpts taken later in an article by Erica Thompson and John Sussler entitled Supermax Prisons, High-Tech Dungeons, and Modern-Day Torture. The Supermax Control Unit, or lockdown concept beginning at Marion, Illinois in 1963, has been continually criticized by human rights organizations. Though these concerned individuals argue that it has never been demonstrated that repression brings desired results. Supermax lockdowns seem to be designed to break the defiant spirit and behavior through psychological deprivation, in which prisoners are stripped of their individual identities. In 1987, a report of Amnesty International, it stated that the Marion method violates the United Nations standard of minimum rules for treatment of prisoners, that there is hardly a rule in the standard minimum rules that is not infringed in some way or other. Security measures override the individual need for human contact, spiritual fulfillment, and fellowship, and this is the excuse for constant show of sheer force. Such conditions constitute psychological pain and agony tantamount to torture. In a 1990 report by a subcommittee of the House Representatives on Courts, Intellectual Property, and the Administration of Justice, it expressed concern about the amount of time they cooped up inmates in their cells in relative isolation. They have limited opportunity for production and recreational activities in their cells due to the highly controlled environment. That there is a need to develop a more humane approach to the incarceration of the maximum security prison population. Since 1983, the Marion model, physical and psychological control, was replaced by the new Federal Control Unit, Colorado ADX. Human Rights Watch in 1991 found that the single most disturbing aspect of their management was the trolling for rations of control units in prisons. The report continues. Inmates are essentially sentenced twice, once by the court to certain period of imprisonment, and the second time by the prison administration to confinement in maxi. Max is under extreme harsh conditions and without independent supervision. This second sentence is open-ended and limited only by the overall length of the inmate sentence and is meted out with without the benefit of counsel. The increasing use of prisons within prisons leads to numerous human rights abuses and frequent violations of UN standard minimum rules for the treatment of prisoners. Super prison control units differ from lesser security institutions in three principal respects. First, other prisoners are out of their cells for an average of 13 hours per day, but super prisons are permanent lockdown facilities. In other words, prisoners are caged in their single cell approximately 23 hours per day. Prisoners are not allowed to communicate with other prisoners. Complete isolation is assured. Prisoners must eat, sleep, and live their entire lives alone in the cell. No religious service. Censorship of reading materials strict. A person needs human contact. On the rare occasion when a prisoner has an opportunity to leave his cell, he is fully shackled, hands, feet, and waist, and he is flanked by several guards. Minor rule infractions result in severe punishment, ranging from prisoner being fully strapped down to his bed to a visit from the cell extracting team. The legal effect on an administrative transfer is that the prisoner has no legal recourse to challenge the designation. A prisoner can be held indefinitely in Supermax because of that designation. What is going on in the United States in the name of law and order is obscene and unprecedented in history. We must educate ourselves, speak out, and take action immediately. We must make a concerted effort to intensify the debate on all fronts. We must be relentless. There are no valid excuses. We ask if ADX complies with the legal resource guide with regard to inmates' rights and disciplinary procedures. A thorough investigation may reveal that they don't give inmates reasonable access to legal materials. Federal prisons don't always maintain inmate law libraries and meaningful books where an inmate may purchase legal materials outside the prison. Even so, the officials may not allow inmates to retain them. They may not allow a reasonable amount of time to conduct their own legal research, to prepare legal documents, or to retain publications they receive. Violations of prohibited acts do not appear to carry sanctions that correspond to the severity of the events, as related to segregation, loss of good time credits, loss of privileges, and verbal warnings. Yet it appears that they will allow retaliatory and capricious disciplinary actions. On July 1st, 2008, I wrote a second letter to Warden Ron Wiley about ADX. Dear Warden Wiley, unfortunately, certain members of your staff have failed to comprehend the significance of their role as agents under your supervision. My last letter to you, dated February the 7th, 2008, attached herewith, I ask for your support in making corrections for abuses. Apparently, you did instruct your staff to address the abuses by some guards, as mentioned in the attached letter on February the 7th. I didn't make an issue about the abusers. Now, I want to tell you what has happened. Again, this is not a formal complaint by asking for a hearing within the system. I'm now publishing a story for all the peoples inside and outside the U.S. It may be that only a few people care about what happens to the poor souls that ADX puts in solitary confinement, where a few cowardly guards treat inmates with contempt. The abused have no spokesman. In the past, I have chosen to withhold publishing negatives about ADX because of my belief that most of the guards are decent, honorable employees who want only to do their jobs by following the regulations as published in the Legal Resources Guide to Federal Bureau of Prisons 2008. My intent is to identify and expose those who misunderstand their stewardship. What I did not anticipate was guards or authorities being outright liars. To lie reveals lack of character. A person placed in charge of others needs to be upfront and honest, and there is no justification for lying. On Friday at 1:10 p.m., July 18, 2009, David Hinkson's attorney, Wes Hoyt, called me saying he had me waiting for 40 minutes to see his client, David, 800-08795-023. He had spoken to CO Quintina Spelling and was told that all the bays were full. Mr. Hoyt called me suggesting that I call Officer Sproul to see if there was any way he could come into an attorney booth as provided by law, or in the alternative to one of the 8 social booths. I had told Mr. Hoyt about an earlier complaint I registered when I was informed by the supervising lieutenant on duty there is no justification for any staff member to delay a visitor for over 30 minutes unless there's an emergency. In the past, I have myself reminded staff of this declaration and have gotten hasty results. At 1:17 p.m., I called to speak to Officer Sproul or Warden Wiley. Mr. Sproul was cordial and cooperative. He said he'll try to get, and then I'm going to stop here on the top of page 251, and then we'll pick up on page 251 at some point later. Again, I want to remind everybody, this PDF file is on Year of Jubilee with 1E, and you can download it from the Hinkson page and read it yourself if you so care to.